The following segment is sponsored by Martin, Harding and Mazzotti.
Welcome back. Now, as we were talking about at the start of the newscast, a leaked draft by the U.S. Supreme Court to overturn Roe v. Wade could be changing legal precedent that, as of now, dates back half a century. Here to explain this legal issue is managing partner Paul Harding from the law firm of Martin, Harding and Mazzotti.
Paul, can you help us understand what the original case of Roe v. Wade was all about and what it stood for?
Well, in a nutshell, Roe v. Wade it came about as a case in Texas. Texas passed a law that said no abortions unless the abortion is needed to save the mother's life. Well, that went to the Supreme Court in the 70s, and the Supreme Court looked at this and said, no, we're not going to make that criminal. In fact, we're going to overturn that law, and then we're going to write a decision which seemed to imply that the country now has to follow these rules, which they did, that if you're going to have an abortion, it has to be in later term. It can't be early term regulated by the state. And that is the current law as of today.
Okay, so could you tell us a little about the current case that the Supreme Court is prepared to rule on?
Right. So Hobbs, versus Women's Health, and it was a case, it's Mississippi, and they said, hey, any abortion after 15 weeks is going to be illegal. It was appealed, went to the Supreme Court. The normal sanctity of the Supreme Court, we never know what they're going to do. Well, sure enough, there was a draft released which seemed to imply that they were going to uphold the Mississippi law, which would change abortion rights in this country from the day that they issued that decision.
So if this decision, as of right now, isn't final, how did the public become aware of the court's intentions? And is there any chance that the court could possibly reverse course on it?
So, there was a leak, right? Somebody within the court system leaked something, which is really an unprecedented thing, but it got the word out. Anything can change. A draft is a draft, but usually what they do is the majority opinion writes a draft, circulates it, tries to get unanimity, tries to get everybody to agree to it. So yes, it could be a change, but looking at the opinion, which is available for everyone to read, I think what they're going to do is they're going to say, look, guys, state issue. We're going to back off federally. You states, you elect your legislators, you elect your governors. You voted the people that you want to do what you want. We don't see it as a constitutional issue. So we as the federal government, in this case, Supreme Court, we're going to back off.
All right. And the last question that we have is, how do you see this affecting abortion rights nationwide? I mean, it seems like, states basically get the call here or would get the call.
Yeah, I see that exactly what's going to happen. So you're going to have states that are going to, they're going to control there. And again, just because they pass a law doesn't mean that can't still be appealed to the Supreme Court. But they're going to be passing laws as to what they think their population wants. But the truth be told, what are we going to have? We're going to have some states that are going to say that it's going to be very limited or no abortion. We're going to have states that are going to be very liberal. So we're going to have people kind of crossing borders and making trips if they can to get what they think they need. And so I see this as being a tremendous amount of confusion, but maybe just part of our democratic process.
The Supreme Court is expected to release its final official opinion in June or July. For more information covered in our weekly What Are Your Rights segments that you just watched, or to send us a story idea, just go to CBS6albany.com.